May I please, my lord?
Yes.
My lord, I beg to mention one unlisted criminal revision petition, my lord, which is pending before honorable court. So, my lord, this matter may be leased tomorrow, my lord.
List
Matter may be fixed tomorrow, my lord.
tomorrow.
Yes, my lord.
Tomorrow.
Because,
Day
my
after
lord,
tomorrow.
my
Day
lord,
after tomorrow. Tomorrow Wednesday probably DV again will
my
be
lord,
there.
I have difficulty day
Day
after
after
tomorrow.
tomorrow, huh?
My lord,
Then
I
day
have some
after that
difficulty.
Monday. Monday.
My lord, Monday, I may
Tuesday.
be
Any day. Any
out
day.
of station.
Not tomorrow. Any day.
Supposed to list after immediate puja vacation, my lord, but the matter could not list, my lord.
Normally tomorrow's cause list by then by now they must have prepared. So that is why it will be inclusion only because they can count and then get ready and it becomes
My lord, the matter
only
is,
for adjournment. We
My
should
lord,
not list it.
my lord, the matter is that trial court they have fixed 313 of the accused person, my lord.
Mhm.
So only the here matter is the small matter, my lord, only
It's
for
too
recalling
late.
of
3 on 3. Your question petition.
no, my
Division.
lord, no, my lord, recalling of one PW, my lord, IU of the
PW.
case.
Any
Lord-
day this week, Friday, not tomorrow.
Any day, my lord.
Day after tomorrow or Thursday, Friday, any day. Thursday, Friday, Monday, any day, not tomorrow.
My lord, any day, my lord, any day. Matter may be list any day.
When?
Except Monday, my lord. Monday I may
Tuesday.
not-
Okay. Next Tuesday.
Yes, much of it.
Friday, next Tuesday. Okay.
My place, Lordship.
Hmm.
Lordship, I beg to mention item number 5.
Alright.
Yes.
Matter become infructuous, so Lordship, my Lordship may close the matter.
Infractors.
Yes.
Okay. So you want to withdraw? Withdraw.
Yes, just close
Okay.
on matter being infructuous.
Okay, Mr. K. Lolan. Land Council for the petition submits that this matter has become infructuous. This CRPC is closed on becoming infructuous. Okay.
Yes. And Lordship, I beg to mention another item number 12. Lordship, this matter was listed on 23rd 10/2025, whereby the petitioner was directed to take steps upon the respondent number 2 within 3 days.
Okay.
But because of some difficulties, I could not take any steps.
Okay, Mr.
within-
K. Lolan, Land Council for the petitioner submits that he was to take steps upon the respondent number
2.
2. However, due to some inadvertently, he could not take steps upon them. Therefore, prays for further 2 weeks' time to take steps upon the respondent number 2.
2.
Prayer allowed. The steps for notice upon the respondent number 2 by a registered post with AD as well as by usual process within a week from today.
Yes,
List this matter after
2 weeks.
2 weeks. Will the notice will reach?
Yes, he is residing within Itanagar.
Okay. Okay. 2 weeks.
So steps within 1 day or 2 days, I will take steps.
Okay. I have said 1 week.
Yes,
1 day.
Yes.
Not restricted. Okay.
yes. Deeply obliged.
Stay within 3 days. Say, huh?
My please, my lord.
Okay.
My lord, I beg to mention item number 2, my lord.
I think
My lord,
so.
there is defective in the petition, my lord. So therefore, kindly allow me to withdraw this petition, my lord.
Mr.
M. Ratan, my lord.
M.
Ratan.
Ratan, Land Council for the petitioner, wants to withdraw this bail petition with liberty to file afresh after making necessary correction. This bail application is dismissed on withdrawal with liberty as prayed for. Okay.
Deeply obliged, my lord.
Item 24. Who's petitioner? Respondent. Who is for the petitioner? Okay, Mr. Opa, Land Council. Submits that the Land Council for the respondent is under bereavement, therefore prays for adjournment of the matter. He has also taken consent from the Land Council for the petitioner. In view of the above, let this matter be listed after. I think the meeting will be listed on 4th of December. 4th of December. Okay, as prayed for by the Land Council for the Land Council. Let this matter be listed on 4th December. Okay.
My lord, I beg to mention item number 4.
Item 4.
Yes, ma'am.
What do you want in item
Yes,
4?
my lord, the parties have settled before the Lok Adalat.
Okay,
Therefore, my lord, we may be allowed to withdraw this present petition.
okay. Miss
Ji Bachar.
UFO petitioner,
Yes, ma'am.
Miss
Ji Bachar.
G. Basar, Lana counsel for the petitioner, submits that the matter has already been resolved, settled by the parties before the Lok Adalat. And thus it has become infructuous. Therefore, she want to withdraw this criminal revision petition. Stop. The prayer is allowed. This criminal revision petition is stands disposed of as withdrawn. Okay.
That's okay.
May I, Lordship?
Yes.
Yes, Your Lordship, I would like to mention for the watching of FIR, Your Honor, petition in connection with Luktar Tasar and other versus that, okay, for the unlisted hearing, Your Honor.
Unlisted.
Yes, Your
When?
Honor. Today,
Today it may not be possible. Today it's already afternoon. We are yet to start. Tomorrow, day after tomorrow,
tomorrow, Your Honor, then.
day after
Yeah.
tomorrow. Tomorrow list already prepared. Okay. Day after tomorrow.
Day after.
Okay.
Always.
Give your mention memo. Do you have the mention memo? Give.
Yeah, Lordship.
Yes.
Lordship, I'd like to mention item number 23.
2, 3.
Lordship. Lordship, with the consent of the other party, let the matter may be heard on 3rd of December.
3rd of December.
Lordship.
Okay. On the prayer of you are Mr.
J. Saro, Lordship, for the petition.
J.
Saro.
Your name is there? No.
No, Lord.
Appearing on behalf of Mr. R.
R.
Ramsap, counsel for the appellant with the consent of the Lana counsel of the other side. Praise for listing this matter on 4th. When you say 3rd?
On 3rd of December.
3rd December, the prayer is allowed. List it accordingly. Okay. On 3rd.
Obliged.
Yes.
May, my lord. My lord, I beg to mention item number 6. Due to some emergency, the conducting council had to leave, my lord.
Oh,
Therefore, this matter may be adjourned for today and may be listed after 2 weeks.
okay.
I have taken consent from the opposite parties.
Okay. You are Mr.
P. Sring, my lord.
Your name is there?
Yes, my lord.
Okay. Sitting Lana counsel for the petitioner. Praise for with the consent of the Lana counsel. You are
Amicus
that.
Curie for respondent to.
okay. Praise for adjournment of the matter for 2 weeks.
2 weeks, my lord.
Okay, to which the Lana counsel appearing on behalf of the other side has no objection. Accordingly, the prayer is allowed. List is matter after 2 weeks. Okay. Okay. Okay, then just a minute. Huh? The Ms. Dangan, you are here. Am I?
Amicus for
Okay.
respondent. Respondent to.
Okay.
My lord,
Okay.
in this case is they're challenging the charge sheet.
Okay.
Charge sheet, but it's not,
Is there any stay here?
yes, there is.
There is a stay.
Yes. They have, lordship, still, oh, sorry, no stay. No stay, lordship.
Hmm?
No
No
stay. I'm
Okay.
appearing for the first time. So I'm not,
Okay, okay.
not very
Okay,
familiar,
then,
but lordship, what,
Mr. So and so, Lana counsel for the petitioner, prays for submits that the conducting counsel had to leave the court due to some urgency, therefore pray for adjournment. Staff, Miss N. Dange. Who, okay, Miss, okay, Jeannie PP, additional PP for the state, and Miss N. Dange, Lana Amicus for the private respondent.
Mm.
Are
yes, private
also
respondent.
present. Staff, okay, are present and has no objection to the adjournment prayer made by the Lana counsel appearing on behalf of the petition. Accordingly, the prayer is allowed. List is matter after 2 weeks. On which date the updated case diary shall be present. Okay, trial court. Okay, updated TCR shall be produced. Okay.
We may be allowed to inspect the records from the registry because even though the case is challenging the charge sheet,
Hmm.
it has not been annexed in the petition along with the,
If it has already been charge sheeted, then and the trial is going on, then why charge sheet? You are challenging charge sheet. It should have been the trial itself.
that is
Okay.
their lordship.
Updated charge, updated trial court record.
Yes,
Okay,
yes.
okay,
Obliged, my lord.
up to 2 weeks, huh? Yes,
Item number 1,
yes.
Yeah, please, your lordship. Lordship, this is an application under 482 of BNSS, praying for granting of pre-case bail to the applicant Miss Karpi Reba in connection with Itanagar PS case number 74 of 2025, lordship. Lordship, on 14th November 2025, I got one WhatsApp message. Lordship will find it at page 29, lordship.
What's up, Mr.?
Lordship. This is under section 35 subclause 3 of BNSS, notice by the police.
Okay,
From this notice, I came to know that
Page
about
39.
the FIR, lordship. Page 29, lordship. And
29.
629. Through WhatsApp, lordship, in my mobile phone.
okay. Notice
they
for
have-
appearance.
Yes, lordship.
Yes,
Now, on inquiry, I came to know about the FIR, lordship. FIR is at page 25, lordship. It's a long, lengthy FIR, lordship.
okay,
Now, the crux of the FIR is that now the basic allegation against me is that I am having extramarital affairs with the informant's husband, lordship. Now, in the entire FIR, lordship, we will see that whatever domestic violence that has been caused, that is caused by the husband, lordship, not by me, lordship. Now, on registration of this FIR, section 61, subclause 2A, and section 85 and section 117, subclause 2 has been registered, lordship. Now, the 61 subclause 2 is the
61?
lordship. 2A, lordship, that is criminal conspiracy,
Okay, criminal
and
conspiracy.
85 is cruelty by husband
Okay,
and relatives,
and 17
and 17 is the voluntary causing grievous hurt
by whom?
by the husband,
Okay,
not by me,
not by the present applicant.
lordship.
61 2 is the
Criminal conspiracy.
conspiracy.
Now, in the entire FIR, the informant is alleging that since I'm having extramarital affairs with her husband, I'm conspiring with him to cause the domestic violence against her.
Okay,
That is the whole allegations, crux of the allegations in the FIR. So it's a lengthy
so this
FIR,
is
lordship.
abatement.
Now, yes,
of the-
lordship.
Okay,
Now, in the lordship, we'll see that in the entire FIR, starting from the informants alleging that starting from 8 January 2024, the husband has been causing domestic violence against the informant on account of having extramarital affairs against with me. lordship.
Mhm. Okay,
Several dates has been mentioned where domestic violence has been caused
okay,
against
okay.
the informant.
Date wise.
date-wise.
Since 2024.
Lordship. Now, in the entire allegation, lordship, there is no whisper of me physically assaulting her, lordship.
Okay,
Nowhere, lordship. Rather, she has come to my business place and has damaged some properties and has criminally trespassed, lordship.
Mhm.
Against that, I have lodged an FIR also, lordship. Will find it at
You have also lodged a FIR against her.
lordship.
When? Page?
Page 35, lordship. Type copy is at page 36, lordship.
Okay,
This incident is of 6/12/2024, lordship. All FIR. Now, this on account of this FIR, charged already the police has charge sheeted and the trial is going on, lordship.
okay.
And
This is
then
under
this
section 414 and 448.
lordship 447
Charge
criminal
already
trespass.
charge already framed against her.
No, not yet, lordship.
Not
Matter
yet.
was in fact sent for law cadre also, lordship.
Okay. Settled? No.
Yes, no settlement.
Not settled.
not settled.
Okay, you are seeking pre-arrest bail.
Pre-arrest. Now the allegations having lordship extramarital affairs, there is no iota of truth against the allegation, lordship. In fact, I am a business partner of her husband. In fact,
Mhm.
we are running a dental clinic, lordship, together, lordship.
You are also doctor?
No, lordship. I'm a law graduate, lordship.
Not graduate, still pursuing.
Lordship. I'm
What-
pursuing LLM, lordship.
What's in this?
Already
Okay.
completed my LLB, lordship. I'm enrolled in the bar association.
Okay,
And recently, I have appeared in the judicial exam also.
Okay.
lordship. I have annexed the admit card also.
yes,
And I'm a student of Rahul IS Academy also, lordship. I'm enrolled in the coaching center, lordship. Lordship will find that at page 19, lordship.
okay. Yes,
Lordship, this is a pit case where lordship can
yes,
grant pre-arrest bail.
The FIR does not speak about her more particularly, Your Lordship, only a
Mm.
stranger where, if I may take Your Lordship to page number 27, Your Lordship. Just a brief, the second
Hmm.
last paragraph, Your Lordship.
yes,
I'm also in fear for my life due to a recent discovery. I have a voice recording in which my husband and so are heard discussing how they intend to remove me from their life. During the recording, my husband explicitly says 4 times that he wants me to remove from their life.
Hmm.
The nature of this conversation, I'm deeply terrified. This is the only allegation against her, Your Lordship. That is also, since I have
Okay.
seen the FIR, the
So-
enclosures made.
So the allegation is that they are trying to eliminate her.
Yes, this is the only allegation towards her, Your Lordship.
Okay,
There's
Okay.
nothing in the FIR. Your Lordship may call for the CD in this case.
okay. Mr. J. Juni, land counsel for the petitioner. Also, Ms. T. Juni, an additional PP for the state. Start, para. The petitioner filed this application under section 482 of the Bharatiya Nagrik Suraksha Sanhita 2023, seeking a grant of pre-arrest bail, apprehending her arrest in connection with Itanagar Women PS case number 74, 2025, under section 85 stroke 61 within bracket 2 within bracket A stroke 117 within bracket 2 of BNSS Stapa. The allegation against against a petitioner is that, just a minute, it is submitted that the informant just a minute, it's submitted that the accused applicant and the informant husband are business partner the stopper, the informant lodged a written FIR before the OCPS, before the OC Women PS Itanagar, alleging against her husband of domestic violence. Domestic violence, mental and physical harassment, assault, causing grievous hurt, cruelty, criminal conspiracy, attempt to murder or threat to life, word gesture, or act intended to insult the modesty of the women, criminal intimidation and other serious offenses against her husband, Stopper. The allegation against present petitioner is that her husband, against the present petitioner by the informant is that her husband is having an illicit relationship with, illicit affairs with the petitioner, and she has a voice recording discussing her husband and the present petitioner to remove her. It is submitted that earlier the informant, the petitioner lodged an FIR against the informant for causing damage to her property, and then for forceful entering and causing damage to her property. The case was registered and submitted into charge sheet. Registered stuff. The said case was placed before the Lok Adalat. However, it failed as the petitioner did not agree with the settlement. Para. The Atlantic Council for the petitioner submits that the petitioner is innocent of all allegations made in the said FIR. However, she has received a notice through WhatsApp from the IO of the case requiring her attendance. Therefore, she has a reasonable apprehension that she may be arrested in connection with the above PS case. Para. Call for the case diary. List this matter. After a week,
On 2nd of December, Your Lordship.
2nd of December, in the meantime, considering the nature of allegation and the fact and circumstances of the case, it is provided that in the event of the accused applicant being arrested in connection with the above Itanagar women in this case number 7 for 2025, she shall be released on interim anticipatory bail on execution of a bail bond of rupees 10,000 with one surety of like amount to the satisfaction of the arresting authority with the following condition. One, that she shall cooperate and appear before the eye of the case as and when called for. That she shall not.
Your Lordship, if I may, Your Lordship. Lordship, the charge sheet has already been filed, Your Lordship.
Here in this case,
Yes, the
No,
case,
this is
Yes.
recent, I think.
the case is
What is
page number 31.
that is different case.
That
That is in my
that case,
in my,
in his case, charge sheet file, it is Lok Adalat failed. But here, this is a new case
Oh,
only,
yes.
not possible charge sheet. Shall not hamper or tamper with the evidence of the case. Mm. In any manner, huh? Okay. List this matter again on
2nd of December.
2nd of December. Okay.
God bless you.
Item number 3,
Your Lordship, in item number 2,
To withdraw. Yes.
This is joint application filed by the alleged accused person and the complainant. For the quashment of the FIR dated 11/4/2019, it is being registered and numbered as UNPS case number 08/2019.
When
2019.
2019 case.
Yes.
What is the status of the case?
Stage of appearance of the accused person. Your Lordship, I have not been served with the summon, Your Lordship. I came to know from some reliable sources that this matter has been pending before the CGM Chahan.
You have you know, have you given the GR number, which is pending before the
Yes, you know, GR number
Chang,
109 of 2019.
before judicial,
CGM
chief judicial magistrate?
Yes.
Okay.
In terms of the deed of settlement entered between the parties.
There was a settlement.
Yes, they have entered the parties and in the
What was the allegation exactly?
allegation is, Your Lordship, that I have
The register section is 341.
341,
What is 352?
352 is Your
Okay,
Lordship,
506.
punishment for assault or criminal force, Your Lordship.
Okay.
Your Lordship,
So-
however, if we see the medical report
Mhm.
of the complainant, there is no such injuries.
No injury report.
Yes, Your Lordship.
So 341.
Petition of.
So which one is non-bailable then?
The non-compoundable sections are, Your
The
Lordship,
non-compoundable, sorry.
it's 171 and 511.
171 is also there.
Yes, sir. 171 is for
What is this?
undue influence or personation at an election, Your Lordship. And
This is not non-compoundable.
yes, Your Lordship, this is not compoundable, but
How many accused persons are there?
only one, Your Lordship.
Okay.
Section 34 has been, Your Lordship, dropped out in while judge seated the
Okay.
case. Your Lordship, in
Well,
similar
can-
matter, Your Lordship, this court has already got this kind of criminal.
Call for the record. Record need to go.
Yes, Lordship, in the same, there is two FIR, Lordship. One has already passed, Lordship.
Yes.
right?
Okay, where? Have you annexed?
Yes,
Yes,
Your Lordship.
yes, Lordship.
Where is that?
Yeah, it is
Same incident, Lordship,
Same
but to,
In the same incident?
yes, 38, Your Lordship.
Hmm?
Page number 38 onwards, Your Lordship. Annexure 6. Page is 38 onwards, Your Lordship.
same PS, Lordship, but
Date of incident is also same, Your Lordship. Only the
Nature of allegation also same.
same. Yes.
same, Lordship.
So instead of keeping this matter pending, Your Lordship, this matter may be quashed. Your Lordship. In terms of the deed of settlement agreement and relying upon this,
Let us see the allegation, okay? We hold the censure. It's a Dion PS case
yes,
in the same place.
Same place, same accused, Lordship, but the different complainant.
date of incident is almost same. Your Lordship. Place.
Okay, the accused is also same?
Yeah,
Yes, Lordship.
Okay,
Only the complainant is different.
in the same incident. So they have lodged different complaint,
Yes,
means FIR.
yes,
For each one has lodged a different
Yes,
independent FIR, okay,
yes,
to cause harassment.
yes. This is abuse of process of law also, Lordship. हम this matter में भी Your Lordship, quashed.
Okay, during election.
Yes, during election.
he was arrested here in this case,
No, Your Lordship.
not arrested.
No.
So how the charge sheet file what?
But just it is fine.
In the other case, he was arrested.
No, no, in the other case also I wasn't arrested, Your Lordship, but in that case, you know, there was a two accused person, Your Lordship.
In that case,
Accused person. Earlier
okay,
case,
the other accused person,
he was arrested, but not me.
just a minute. Have you annexed, or there is no medical report here, you said?
The medical report is there, Your Lordship. I have annexed, Your Lordship.
You have annexed? Page,
Page number, Your Lordship, 21 onwards. Forwarding of injured person, page number 21, annexed to series. You can have an entire copy, page number 22. On the medical examination report, is page number 23. It is written no external injury seen.
okay, not under influence. No, this is in respect of,
This is in respect of the
this is a medical examination of,
complainant.
so complainant,
Yes.
not in, no external injury. Complainant was fit to be kept in lockup. Okay.
Lordship, in that case, Lordship, PCR might be called, Lordship.
Hmm,
PCR.
there is a, for recording,
Yes.
even to justify to dispose of the matter, probably the record will be necessary, because here in this case, it appears some accused persons were arrested. Now, we do not know.
Yes.
In order to just, to write order also, we need record.
Yes, it's
Will this
confusing, Lordship.
Next week, it will be only a scan copy,
Yes, it's get.
okay?
Yes. Lordship.
Next Monday? Monday, will it be possible? Monday, Tuesday, any day? Without record, it will be difficult to dispose of, because this is not the same case, different FIR. In that case, more than one accused persons were there,
Yes.
or reports also different. There, only one single accused,
Yes.
but then we need some information whether he was arrested or not.
Yes. It is admitted.
I don't know,
But
we
in-
do
in-
not
in
know,
the
but then it
medical-
will be available on record.
Yes, in the medical, the complainant is fit to be kept in the.
And see,
custody.
medical also.
Yes, Lordship.
In-
It's confusing.
It should be in the medical report of the accused.
Yes, Lordship.
He is fit to be kept under lockup.
Yes.
So the complainant is fit to be kept under lockup. Let us see the record.
Yeah.
Dispose of, don't worry. We'll allow you, don't worry, but then have some patience. Okay? Give the record for dictation. Okay, without record, it will be difficult. Okay.
Yeah.
Mr.
Ibam.
Land Council for the petitioner. And I also had Mr. Loilana TP for the state staff, para. This is an application filed under section 528 of the BNSS. For we're praying for crossing of the GR. Where is the GR number? GR number 109/2019, arising out of the NPS case number 08/2019, under section registered under section 341, 352, 506, 511, 171 within bracket F. IPC. You'll say this is a joint application, huh? Filed under section. Call for the scanned copy of the trial court record. Stop. List is matter. Next week,
26, Lordship.
Hmm?
26 or 26.
26. On 26. 11/20/25. Stop. In the interim, the proceeding. It is provided that the proceeding. 27. 27, okay, 27. Of the GR case number 109/2019. Pending before the Court of Chief Judicial Magistrate Changlang shall remain state till the next returnable date. Stop. List is as prayed for, comma, list is matter again on 27, huh? November. Okay.
Item number 7.
This record was my lord called, so.
Hmm?
Trial court record was called.
Record was called for. Have we received the record? Not yet. Okay. If PCR is available, why the CD is necessary? If the case has already been charge sheeted, only TCR would be necessary. Okay, this code directed for both. Okay. So then. Okay. Mr. M. Lana Council for the petitioner is present. Mr. G. Tado, Lana additional PP for the state. Submit said the trial court record is still awaited. Which court? UPR.
My lord, this court has been this case has been listed for around, this is the 6th time. CD was called, TCR was called.
Why they are not sending this matter again tomorrow? Vote for the scanned copy. No, earlier case diary was called for. Yes.
There are
3.
It was said,
Oh, no, the for case diary, I think, yes, 3 times gone. And thereafter, it was informed that case charge sheeted, then trial court records recently only, recently.
my lord, actually what happened, there was a collision. And during the investigation, the person who bought the Fortuner car,
Okay.
he took my
Vehicle.
name. In the main case, I have been granted bail on default, though it's not on merit.
Okay, this is,
This is Doimuk PS case.
okay, this is also collision.
Yes, there was a collision. And during investigation,
The why it's taking long,
yes, earlier,
arising out of same incident?
no. My lord, what happened?
On the same day?
30th July, there was a collision, there was an
Okay.
accident
Hmm.
between Fortuner and a Tata Sumo.
Okay,
During investigation, it was found that the Fortuner was a stolen vehicle.
okay.
So the person who
Now,
bought
the petitioner is the.
he took my name.
Okay,
Therefore, I was already in jail.
the Fortuner belongs to the present petitioner.
Yes.
Okay,
In Itapia's case, I was granted bail on default.
okay.
As on that, now I have already spent 90 days in jail.
90 days.
Yes. And all the co-accused, prime accused, all have been granted bail. I'm
Now-
only the person
Oh.
who is,
Now, after expiry, I probably then 90 days. What is the maximum punishment here?
maximum punishment.
It's
if
90
this
days,
FIR is-
statutory period is 90 days here.
60 days.
60
Hearing
days only?
days, yes,
Why 90 days? Or charge sheet filed on time?
yes.
Okay, then probably there's some case against you. Anyway, so what is the TCR? We have called for TCR. Charge already framed, you don't know. Okay. Trial court record is still awaited stuff, huh? The para. CGM UPR. No, call for, in the earlier occasion only it was called for. This can copy of draft or record. It was called for on Friday. In view of the above, comma, is, when do, next week or when?
If
Please this
it
matter.
can be done as early as possible, since
Next
I
week,
was,
okay, next week, huh? In the meantime, the registry shall issue reminder to, reminder for the trial court record from the chief judicial, the court of the chief judicial magistrate, UPR. Okay,
can it be listed this Friday?
Hmm?
Can it be
next
listed
Friday,
this Friday?
this Friday. I have no idea, is it possible?
It's in UPR.
Monday?
It's a calling of his service letter pertaining to quote and quote communications.
That is why, register, that is why, register,
Just see
you can
the
go.
project with you.
Tomorrow, no, Friday, Monday. Give some time, because they need to prepare, they need to send again. This order, today is gone, and tomorrow only they will be able to send.
There is no such as me tempering any evidences, because all the stolen vehicle has been.
No,
recovered.
you see, let us count the time for the registry also. Today evening only they will get the order. Tomorrow they will be able, it will be uploaded morning or this evening or morning. And then
Monday.
tomorrow they get time to prepare all those. They will be able to see, they will be able to see. Then see, and then day after tomorrow, it's not possible. So Monday, okay? Monday or Tuesday? Tuesday. Let us ensure. Because, no point listing it only for adjournment. Not yet arrived, okay? And let us ensure on Tuesday.
Lordship, holiday Tuesdays.
Hmm?
Holiday, Lordship, Tuesday,
Okay.
25th.
Then Wednesday, okay. Tuesday holiday, okay.
Item number 8.
I'm extremely sorry, Your Honor. Kindly, I may be protected with the entry protection in item number 3, Your Honor.
There is a stay order,
Okay, then.
yes.
What?
You didn't pray, I granted. I granted. Hmm.
The Lordship last time called for the TCR. Your Lordship actually heard this matter last time.
This court,
Yes, madam. Regarding the quantity, madam. And because the police, what they did.
no, thereafter it was heard by
Yes,
so
madam.
many courts. What happened then?
Then TCR was called ultimately. That's why it has been listed again today.
Earlier it was without calling TCR,
Yes. No,
it was court only. I
when
think.
we moved the bail application, they said that matter has been charge sheeted. Therefore, this TCR was called.
Yes,
In this matter, what we saying in this matter, madam, the police Lordship will kindly see type copy page 24.
just a minute. Okay, charge sheet filed against him under Okay, charge sheet is filed against him under 21B only.
Yes.
But then court found that it should be 21C.
No, yes, my lord, during the bail,
Okay, during the bail.
yes. That could not have been done by the learned
Yes,
court.
yes. Oh.
Otherwise, he would have been entitled to bail at that point of time.
Okay, so the trial court came into conclusion that it should have, the offense should have been registered under section 21C.
Yes,
21C attract.
yes.
Since case has already been charged sheeted, then what is the status? Have you seen?
No, Lordship, I'm extremely sorry. This was re-endorsed to one of my it is PT, but she was under impression.
Now from the,
I don't know.
there is no order sheet of the trial court. At what stage it is?
In the otherwise also, Lordship, this rejection bail order was not challenged by the learned by the appellant since the trial court found that there is a
Because this finding probably you may have to challenge, because although the case was charged sheeted under 21B, but then the trial court came into conclusion that it should be 21C. This probably you have to challenge, because how do we conflict? How do we come into different conclusion when he found it?
No, madam. Lordship, may kindly see the entirety of the matter has to be seen first. The prosecution didn't say that it comes under C, madam. How the court can come into that?
No, that is why, under the circumstances, since he has come into such conclusion,
Yes.
it has to, you have to challenge this order.
No, Lordship, but we are praying here is these all.
Now, unless you challenge this, then how do we
No,
come
madam,
into different conclusion?
Madam,
When you challenge it, then findings on our reasoning will have to
madam, this,
yes,
Honorable Court-
justify that this conclusion should not have been come by the trial court.
madam, otherwise there's madam, parallel jurisdiction regarding bail, madam.
No, that is why.
Yes, madam.
No. So because you are agree by this order.
No, we have not challenged this order. What we are saying is these are all mitigating.
Now
circumstances.
that is why I'm saying
Yes.
how he has already come into some conclusion.
Yes.
And then how do we come into different conclusion unless you challenge this?
No, madam.
If you challenge this,
My lord,
then this can be set aside quas and then
no, Your Lordship, what we are saying is we are not saying that this order should be set aside and quiet.
now
but-
unless it is set aside, it
No.
stay.
No, madam. What we are saying is, after looking into the entire matter, this honorable court will definitely apply judicial mind, my lord, and grant bail to me. That's all we are praying here.
No, in order to grant bail,
Yes.
that finding is necessary.
Whether it is 20, it should attract or it retracts in the present case,
Yes.
it's 21B or 21C. The trial court, who is going to try the case, he has come into conclusion that it is under 21, it should attract 21, this case attract 21C.
That conclusion during the trial, the learned court.
No,
ought
that
to
is why,
have
that is
that.
why. That is why. It was not during the trial. Then you should challenge this.
Madam, if you
At the moment,
Yes.
he ought not to have come into this conclusion. You have to challenge
Madam,
by way of criminal revision.
what we are saying is, madam, even if this honorable court has the powers to.
Now,
grant
now, you
regular
see,
bail-
now you see, since although he has come into conclusion, he says this, so leave that, now you grant. This cannot be, because there is already conclusion arrived by the trial court that the amount is, amount attract 21C, not 21B. This is his final order from his side in respect of the quantity. Now, unless you challenge that, in another bail application, we cannot come into that conclusion. We cannot set aside this order.
No, we are not saying, madam, to set aside the order, madam. What we are saying, we are praying that this honorable court may kindly grant
Because
bail.
it is going to affect you later on also, in the trial also, unless you challenge it.
No, that we will look into a different manner, madam. What we are here is simply praying for bail, madam, regular bail.
Now that cannot be. You have to follow the procedure. You have to challenge so that this order, this court pass order, setting aside quas and then direct, and also grant bail. After that,
Both ways, this
or
honorable,
direction.
this
that-
honorable, both ways can do, my lord can grant regular bail, my lord, by looking into the entire matter in manner in which.
I don't know if unless there is a challenge, if this court can
No.
set aside or quash. Whatever,
we are-
the conclusion came by the trial court and without challenge
No,
being made by.
in the bail application, we have not challenged the order. In the present bail application,
No, first, I think since this is the conclusion, you have to challenge that, yes.
that we have not.
Now, when the trial court came into this conclusion, if you think that this is a wrong conclusion, then first you have to challenge this, and thereafter only this. Let us come into conclusion that this is not 21C, it should be 21B.
No, what we are saying
And
here
then
is,
bail.
what we are saying is the manner in which bail was rejected. Later, but the court below has
But that is why there
made
is,
an error, my lord.
there is error in the bail.
Yes.
So that error has to be challenged. If it is subsequent bail or bail only for bail, without such observation, this court would, of course.
Otherwise, the lordship was convinced last time, my lord, with the manner in which the seizure was made, lordship.
Now this court has changed.
No, it was changed, but otherwise, my lord, the manner in which seizure was done, the learned court.
This court has become a little wiser.
Learned court could not have passed such an order.
Yeah, that is there. Because unless there is a trial, he could not have come into that
Yes.
conclusion. So now in the bail application that we cannot. That is what I'm saying. First of all, you challenge this and then this probably will go.
Okay, my lord,
Because
then
this is not a time, this is a bail application, bail disposal. That was not a time to come into actually that conclusion. It should have been in a trial.
we may be allowed to withdraw the petition and file afresh. my lord.
That will be better. Because let us first decide this and then bail. Okay? Because otherwise you'll be kept 180 for 180 days. Okay.
I don't know, my lord, TCR has come or not, my lord, because
No, this is, this year,
TCR was
they said
called for.
this year there no any order,
No,
order sheet, only the bail rejection order, which you have already annexed. And nothing. This is only, I think, the case diary.
TCR was called for.
TCR was called for, but the last time, it seems. This is only the record of the case diary only. No. This is, the police paper is there, but no other order. From here. we
Earlier CD was called for and then, my lord,
only the police paper and then no order sheet. We do not know what is the status of the.
Lordship, earlier the CD was called for, but the matter was seated, Lordship. Then again,
Okay.
the TCR was called for, Lordship.
Okay, Mr. P. Tapo, Clarence Counsel for the petitioner wants to withdraw this bail application with liberty to file a fresh, if so advised. File a fresh, staffer. This bail application is dismissed on withdrawal, as withdrawal. No? Okay,
with liberty.
with liberty as grateful.
Public.
Matter number 9.
Yes.
But this is a bail application, madam. The section 483, BNASS corresponding to 439 of the CRPC, madam.
Just a minute. B. This is bail application.
Bail application.
Okay.
In connection with the Yomsa Police Station case number 2 of 2025, my lord. The accused was arrested on 15/10/2025. As on today, more than 1 month, he has been in the custody, my lord.
Which PS case? Not allow.
Yomcha Police Station.
Not allow.
Not allow, my lord. First, because FIR was registered there, my lord. My lord, may straightly go to the, my lord, to FIR, my lord. FIR, my lord, will find a page number.
Type copy 21.
That will find FIR. May I read, my lord? 21. Type copy, my lord, will find page number 21. To the official in charge, police station Yomcha, dated 13/10/2025, FIR. Respected, it is to inform you that my sister Srimati Yata Gandon Potom has been gunshot as per verbal statement of victim and surrounding observer while retiring back from her shop at around 9:30 p.m. on so and so. The surveillance camera available near the spot from the shop may kindly be checked in the order for cross interrogation so and so, my lord. This is the FIR. My lord, what happened on 13?
Has been gun.
My lord, gun. She was shot by a gun, my lord.
Okay.
Very unfortunate incident happened. What happened, my lord? It's like, my lord.
And as per verbal, okay, as per
Yes.
verbal statement.
She injured some gunshot, my lord. It is admitted point, my lord. She sustained some gunshot, my lord, on 13/10/2021. But the question here is, my lord, how this gunshot took place, my lord. My lord, here what happened, my lord? This bail applicant accused is the, my lord, officer in charge of the Yomcha police station. He is the officer in charge of the Yomcha police station.
Accused?
Yes, my lord. Now, this present bail applicant accused, my lord. So what happened, my lord? This one, my lord, juvenile, my lord, the juvenile in conflict with law, my lord, what Raj Munda, my lord, is aged about 14 years, my lord. I will come with all details, documents, my lord, later on. First, I'll just give some relevant facts, my lord.
Just a minute. Whether here in have we called for the record?
Yes,
Case that we have for.
Case there is there. Okay.
So here what happened, my lord? The accused.
Now, just a minute. Probably if the case, have you gone through the case study? Okay. Yes.
Accused is the officer in charge. Was the officer in charge police station, my lord. So what happened, my lord? This one child in conflict with law, juvenile in conflict with Raj Munda, my lord. Basically, he is a son of a one, my lord, laborer from Tea Garden, my lord. And poor family, he belongs from poor family. What happened, my lord? Following the death of the mother, the father of this juvenile, my lord, since he was not in position to look after his boy, my lord, so he handed over this boy to one of the relative of the accused, my lord, some Bhaskar or Yomcha. So with a request that kindly take care of my child, provide education or all those things. Then what happened, my lord, when the child was kept by one Bhaskar Yomcha, who is the relative of the accused person, it was found this child is very notorious, my lord. Very notorious, not ready to stay in the house, roaming here and there, and he was become very difficult to control him. So later on, what happened? This Bhaskar, he again handed over this child to one of his relatives, saying that you kindly look into this child, who is found to be very notorious. Kindly. So in the meantime, what happened? In Yomcha market, this particular boy, juvenile in conflict, was found just roaming around the market. Then this Bhaskar, he telephonically called the accused person, who is the officer in charge, police station. He called him telephonically saying, you being an officer in charge, kindly call that boy, call him to the
this victim.
Yes, my lord.
Okay.
He telephonically called the not victim, not victim.
Different person.
Different accused, who is the officer in charge.
Now call whom?
My relative, he called me.
Okay.
Call me. Since I am the officer in charge of the police station. So he called me that kindly call him to the police station. You call this guy so that he should not go around here and there, and so that he should not commit something wrong. So accordingly, on good faith, I called this child to the police station. I reprimanded him. I say that you cannot go around all those things. You straightly go back to the house. But this child was found to be very reluctant, saying that he would never go back, return to the home. So he was very reluctant. So considering all this aspect, so at the request of relative, then this accused person thought, okay, since I am a police officer, so that if I keep for some time with me, so that I may be able to control him. So in that way, I took him in the month of August 2025 in my house with the solemn intention to help him so that he can be rectified, so that he can be later on sent back to the home. This is for the solemn on good faith. I started keeping him in my home since August 2025. What happened, my lord? That during this time, my lord, I have been instructed by the executive order by the administrative officer to prevent this straying of this wild, these domesticated animals, pigs, all the surroundings, these agriculture fields. So that for that, to carry out the duties, I took 1.22 rifle in my vehicle. So whenever I used to go for duty, I used to carry in my vehicle. So on that unfortunate night, what happened after coming from the duty, I kept this gun in my vehicle, and therefore I left for my room. So later on, it was found, my lord, that this guy, this juvenile, he secretly took the gun with him without my knowledge, and he went somewhere and he shoot for some birds. So in the process, it hit the victim.
By the juvenile.
Yes, by the juvenile, and this is basically the case. Now, so far shooting of this victim
In
is
the evening,
in the evening.
9 p.m.
Yes, 9:30 p.m. So
In the evening, 9:30 p.m., he was shooting for the bird.
it is now this child will know, because I am nowhere involved. I don't know, because that will be even disclosed by the, I think.
Must be old.
I was in my home.
Okay.
I was in my home. My lord. Then this guy, then later on I came to know, then when I came to know, then we took to the child, and child has been sent to the juvenile home at Pasigar. These orders already I have enclosed.
Okay.
So since I myself is a police officer in charge, I went there and I was arrested. Now, my lord, so far criminality, so far concern about shooting, my lord, my role is nowhere there. Nothing is not there. Now, in the meantime, my lord, I have been suspended again, my lord. Now, only the allegation against me is one, my lord, that this .22 bore rifle, my lord, this is a surrendered gun. It was in the police malkhana.
Okay.
That is the allegation against me. And I have to be very candid and honest, my lord, that since I was having some issue with my lord, pistol, that I took that rifle for this duty, my lord, with me in the vehicle, my lord. This is only the, my lord, the laches on my part, my lord. Otherwise, my lord, I have nothing to do with this, all these alleged offenses, my lord. Now, my lord, may I come to now sections, my lord. Section, my lord, registered is section 125B of the BNS, my lord. This is a bailable offense, my lord. Endangering life.
Just a minute. 125?
125B,
what?
BNS, my lord.
What is it?
Act endangering life or personal safety of others. Now, my lord, there is nothing, no ingredients, my lord, there, this section will be applicable to me, or attracted to me. But otherwise, this is bailable offense.
Bailable?
Bailable.
Okay.
125B. Now, my lord, next section is 1182, BNS. 1182, this is a voluntarily causing grievous hurt.
1182?
118 subclause 2, my lord, of BNS.
Just a minute. It looks like 115. 115.
I think it should be 118, I think. Wrong type maybe, my lord, because 115, 115 will not be applicable, because 115 is in respect of. Well, this is 115 is a lesser offense, my lord. But this case will not come under 115, my lord. It's only for voluntary causing hurt, which is a bailable offense. But this case will come under 118, my lord.
Okay.
118 it will come. because my lord, gun shot and causing
Dangerous weapon,
grievous
so,
injury, my lord. So definitely 118 will come,
It is 326 equivalent.
my lord. Yes, yes, my lord.
Hmm.
Now, my lord, question. This voluntarily causing grievous hurt by dangerous weapon, my lord. Here, my lord, there is no connection with me, my lord. Because it is not me.
It was
It was the
JSS.
juvenile, my lord, child in conflict with law
Hmm.
who sought it. So I have no connection at all. So far, this voluntarily causing grievous hurt, this is non-valuable section, my lord, which is not at all attracted against me, my lord. Now, section 109, again, it is registered as an attempt to murder, but I doubt, I think this section, even it will may not be.
109 also there.
Yes, 109 is also.
It's not in the FIR.
It is not in the FIR, but maybe because of the, yes, my lord, but FIR doesn't disclose these ingredients, my lord. Because even that child in conflict with law, I think he never intended to murder or attempt to murder or knowledge. Otherwise, also this section is also not attracted to me at all, my lord.
109.
1091 PNS.
1091.
Yes, ma'am.
It is not in the FIR.
It is not in the FIR.
Okay.
It is not in the FIR. Or otherwise, also, my lord, I had nothing to do at all, my lord.
Hmm.
Now, my lord, come to the arms act, my lord.
25B, 1B.
Section 25 1BA, arms act, my lord.
Hmm.
This is if anyone has in possession of any firearms and ammunition in contravention of section 3, it's punishable up to 2 years, which may extend up to 5 years. Arms act, my lord.
Hmm. 25 1B.
25 1
B, A.
capital B
Small.
A, my lord.
Hmm.
My lord. So here, my lord, my case is as I said, my lord, this gun, my lord, it was taken from the Malkhana. It was the surrendered gun.
Hmm.
So this was taken to discharge some, my lord, official duty. This is not something, my lord, for his own purpose or something like that, my lord. So this section is there. Then, my lord, 27 1 of the arms act. This will not be attracted to me because I had not used that gun. At the most, my lord, may 25 1BA. I was possessing at the time for some time. I took with me and I kept in the vehicle. I have not used the firearm. This is the case. Now, my lord, kindly turn to page number 25, arrest memo. Why I am referring to this arrest memo? Now, my lord, now because of this so many some judgment, my lord, interpreted about Article 22 of the Constitution, Section 47, 48 of the BNSS, my lord. Recently also, my lord, judgment affirmed, my lord, that Apex Court has affirmed nowadays, my lord, at least this has become mandatory, that only arrest memo giving the reason of ground is not sufficient, my lord. And this has been made very clear, my lord. I will show the judgment of recent judgment, my lord, of the Honorable Chief Justice, my lord, saying, my lord, onwards, any arrest, my lord, has to be, ground of arrest has to be given in written form, my lord. This has been made the law, my lord. This has been interpreted written form and under any circumstances not beyond 2 hours from the time of arrest. Now, this has become the settled proposition of law, my lord. Now, after Bibhan Kumar judgment, then Purkhas, so many series of judgment. Now, latest judgment, my lord, this month or last month only, I will place that judgment, my lord. This has given a very clear-cut guidelines that in the arrest memo, here is the case, my lord. Apart from the merit of the case that I am entitled for the bail, I am just raising some technical issue which goes to the root of the arrest because law is very settled now. Once this is not complied, then entire arrest, subsequent remand, everything becomes illegal in the teeth of the Article 2247 and the series of judgment by the Honorable Apex Court as well as our own Honorable High Court also, my lord. So my lord, one ground is my lord, no written ground, nothing as required under the law has been given. This is on technical aspect, my lord. Now, my lord, kindly turn to page number 26(7). This is the, my lord, executive order issued by the additional deputy commissioner, whereby, my lord, the order has been passed that there are so many, my lord, domesticated animals like pig, goats, my lord, they are creating nuisance, so that prevention is required, my lord. This is the order, copy given to me, my lord, OC Police Station, my lord, 3rd September 2025, my lord. And my lord, kindly turn to page number 29, my lord. This is the, my lord, forwarding letter by the police, my lord, of the child in conflict with law, my lord. Now, may I read in the, my lord, second paragraph, my lord? During the course of investigation, I have recorded the statement of complainant and the CCL Sri Raj Munda. Then thereafter, the CCL was forwarded with his local guardian Sri Kurli Gadi at Alo. Local guardian, my lord, I am the accused person, my lord. The CCL was then forwarded to the Zonal Hospital Alo to conduct his medical examination. As the CCL Sri Raj Munda was then forwarded with his local guardian, and his guardian was instructed to report a child-friendly corner on so and so. Then I, along with police personnel, left to PO. At PO, I have seized 1.22 rifle single barrel number so and so, weapon make so and so, and one telescope seizing was done under the photography so and so. The seized item was then brought back at police station and so on. Thereafter, the CCL was brought before me on by Kurli Gadi, and he was apprehended by in presence of so and so and so and so, my lord. Thereafter, my lord, kindly turn to page number 31, my lord. This is the order passed by the principal magistrate, my lord, sending the, my lord, this CCL to juvenile home, Pasigat, my lord. This is the order. Then my lord will find page number 33. This is the social background report of the CCL, wherein, my lord, his entire history is given, my lord, that under what circumstances he was with them, my lord. Then, my lord, bail
Where is
application,
it?
my lord will find at page number
No, detail history of the
page 33.
33.
So and so.
Okay, social background.
Yes, my lord. His social background, all those things, my lord.
Okay.
Then, my lord, I moved one bail application, my lord, before the learned trial court. That was rejected, my lord. Then, my lord, page number 42. My suspension order, my lord. I have been suspended even, my lord. So therefore, my lord, now my
This is bail order.
my lord will find it page number 38, my lord, bail order. Yes.
Bail rejected.
Bail rejected once, my lord. This is the second bail application. Then 42 is the, my lord, this suspension order. Now I am in the suspension, placed in the suspension, my lord. And since question of my influencing all those things is not there now, since I have been suspended from the job, my lord. Now, basically, my lord, this is the basically fact of the case, my lord, that this particular incident, my lord, and my lord, my medical document also, I am having some pressure issues also, my lord. My lord, the entire facts of the case, this is completely, my lord, accidental case. There is no, this is completely an accidental case. There is no dispute about it, my lord. And since I don't know the victim, I don't have any personal knowledge of the victim. And this CCL also has nothing to do with the victim. most probably he went there, why, what he did, because he was very notorious, my lord. And under such circumstances, this alleged incident took place, my lord. Now I fully cooperated with the investigation. This is not the fit case where I should have been arrested even, my lord. Because my lord knows that arrest is something, because this offense alleged is below 7 years. So far my is like this 7 years below. Then my lord, law is very clear on that point, that only because someone has committed offense, that does not ipso facto enables the police to arrest immediately. There should be a reason also, satisfaction also, why arrest is necessary. Repeatedly, my lord, series of judgment is saying, my lord, it is not something that automatically arrest is to be done, my lord. And in my case, my lord, this is not the case where I should have been detained for more than 1 month, my lord, for my no role, only because sometime I took this boy just out of humanitarian ground with my custodian. I wanted to train him to make him more disciplined. That is only the mistake, my lord. An old man, my lord, and I have my family, children settled, and I'm a government official, responsible officer holding the post, my lord. Now, my lord, my grounds of bail, my lord. First, my lord, no prima facie case of criminal action from my side, my lord. There is no mens rea, my lord, at all, my lord. And investigations almost substantially complete, my lord. All this gun has been seized, everything has been done, nothing is to be recovered, my lord. And this is the case where it is very clear this CCL has sought the gun, my lord, fully cooperated with the investigation, my lord. Therefore, my lord, considering all this ground, my lord, and there is no risk of even tampering also, my lord. So this is a fit case, my lord, that I may be allowed to go on bail, my lord. This is not the case I should be detained for 1 month, my lord. So no fault on my part. Because in law, my lord, criminal liability, vicarious liability cannot be held so far the criminal law is concerned. Even for the crime committed by my own son, how I can be made accused, my lord? It is unknown. This vicarious liability is completely unknown so far the criminal law is concerned. But I'll just place one recent judgment, 2025. It's a judgment of November, this month, 6 November 2025 only, where this, my lord, now it has been mandated that this writing of the grounds has to be given within 2 hours. Get to in some urgent cases, but beyond that 2 years cannot be, 2 hours cannot be. There are 55
This is regarding?
regarding, my lord, this mandatory requirement of giving ground of arrest to the accused person. And if it is not done, this is per se illegal. This is the latest judgment, my lord, taking care of all the earlier judgment, including the Bivan Kumar judgment. And since there was some confusion, that's why now, because earlier, my lord, the issue was that whether the writing is required or not. Because sometimes it said that orally, if it is satisfied, the law was not clear. This judgment has now made very clear that it should be in written form. It cannot be on the oral form, my lord. Now, may I read, my lord, just 2, 3. This is a 6 November judgment by the Chief Justice, Honorable Chief Justice, and just para 55, my lord. I'll just relevant portion I will read out. It goes without saying that if the above said Schedule 4 supplying the grounds of arrest in writing is not added to, the arrest will be rendered illegal, entitling the release of the arrest.
You're reading paragraph 45?
55, my lord.
Sorry, 55.
55. Now then 56 conclusion, my lord. Just 56. Let's read the 56, my lord. In conclusion, ratio of the judge. It is held that, may I proceed, my lord? In conclusion, it is held that the constitutional mandate of informing the arrestee the grounds of arrest is mandatory in all offences under all statutes, including offences under penal code, now BNS so and so. the ground of arrest must be communicated in writing to the arrestee in the language she or she understands. In cases where the arresting officer person is unable to communicate the ground of arrest in writing on or soon after arrest, it be so done orally. The said grounds be communicated in writing within a reasonable time, and in any case at least 2 hours prior to production of the arrestee for remand proceeding before the magistrate. In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal and the person will be at liberty to be set free, my lord. Now the law is been made very clear cut, my lord. In every arrest, my lord, this arrest memo and recording that just reason of arrest, that formality portion, that is not enough. The ground of arrest has to be very specific to the accused person, giving him information, the basic facts, and what are the materials against you, what are the reason why this has been arrested. This has become mandatory and it has become in writing, my lord. Now, there is no another thing that cannot take the play, that there was orally, it was informed orally, that this is not there. Now, law is in that respect is very clear, my lord. And my lord, our own judgment, our own High Court judgment regarding NDPS case, my lord, that too, my lord, section 37, where there is a, my lord, bar. Just para 16. In NDPS case, as my lord knows, there is a bar, because section 37 says that you have to make the satisfaction. Unless there is no prima facie, nothing, then only bail is entitled. But this judgment is saying, considering all the series of judgments, saying that when this particular requirement, mandatory requirement of law is not complied with, then even section 37 will not prevent the court from granting the bail, and the accused will be entitled for. My lord, para 16. I'll just read para 16. In the instant case also I discussed above, it is saying that there is no mention of ground of arrest in the notice issued to the present accused petitioner under section so and so. And except the name, address, and case number, there is no mention about any other particulars of the offense as well as the grounds of arrest. So from the proviso of section so and so, it is saying that there is a clear violation of mandate of Article 22(1) of the Constitution. And in such case, in spite of statutory restriction under section 37 of the NDPS, this court is of the considered opinion that for the violation of the Constitution mandate contained under Article 22 of the Constitution, the arrest of the petitioner is vitiated, and it may be a sufficient ground to consider his bail application in spite of rigor of section 37 so and so and so. So basically, my lord, this portion is my additional ground. Otherwise, on merit even, my lord, that I am entitled for bail, my lord, considering, my lord, I have no role at all, my lord, for the very unfortunate incident happened, my lord. But fortunately, my lord, the victim is recovering, is good. That is the very fortunate thing happened, my lord. So, on merit also, my lord, I am entitled, or otherwise also my entire arrest, subsequent remand, everything is illegal, my lord. And law says that I am entitled to be released on bail. Okay, my lord, let.
Yes. Okay.
Yes, case study lordship, we have received the statement of lordship, the accused lordship, but CCL statement not been annexed lordship. He has been interrogated lordship, but his statement is not annexed in this case study lordship.
What is there then?
Lordship, CCL lordship, his statement lordship, the child conflict law lordship. CCL lordship, this accused child lordship, his statement is not been lordship, annexed lordship in this case study lordship.
Okay.
And lordship, moreover
This is
lordship,
case diary of this present case only?
yes lordship.
Okay.
Only
So,
this,
but then
this
CCL, that he, the
This is
investigation is
JJB lordship.
on a JJ.
Is less Lordship.
Each case will be inquired by the JJB.
Yes, Lordship.
before the-
Interrogated Lordship, yes, Lordship.
Hmm.
Lordship, that part is there, Lordship, and here, Lordship, the only Lordship, the investigation is pending, Lordship, for Lordship, forensic Lordship, examination of the weapon, and Lordship, moreover, furthermore, witnesses examination, Lordship. That's it, Lordship.
The statement of the CCL would be
My lord, to my humble, basically the prosecution is not saying also I used it, but this is not the even
no,
the
no. His,
prosecution.
his statement probably would make it clear that how he got it.
Of course, my lord, as on today prosecution case, forwarding everything is showing, my lord, conclusively, this was the CCL who used the gun, my lord. There is nothing allegation that where I am involved at all, or nothing, there is nothing on the record. Okay, my lord, that part is there. Of course, this honorable court, if he wants to look into that, is but another aspect, my lord. The question now becomes when this honorable comes to know there is a violation of a mandate of Article 22 of the Constitution of India. There is a violation of Article 47 of the thing. My lord, then whether there is a CCL, even let's assume that there is an incriminating statement has been made against me. Assuming, my lord.
Okay.
Everything they have said that it was me who has sought. Even then, my lord, laws mandate us, my lord, that cannot be. Then now, my lord, this judgment is saying, my lord, in such situation, what is to be done, my lord? After release, if the prosecution thinks that no, it has to be rearrested, then again they can initiate the process. My lord. This has been very clear in this judgment,
So where have you stated in your petition
my lord.
that no ground has been? That ground not taken properly. Hmm. That is not a ground. Okay, then that in that case, the statement of the let us see the statement of the juvenile in conflict with law.
Listen, my lord, but considering my lord, my criminality,
Yes.
yes. But
Yeah.
is it the case where I need to go for such circumstances extent
just,
for 1 month, my lord?
Well, why otherwise why it is half the case study is not
Lordship,
complete?
Lordship, actually, this we had called the case study from the PS Lordship, but the JJB we have to call the Lordship.
Okay, so JJB. Okay, inquiry is from the JJB.
And last occasion we have not called the statement of the CCL Lordship. Lordship will decide Lordship whether it's required or not at this stage, Lordship, because Lordship, as it is understood that the prosecution has not been
No
followed,
means
Lordship.
there nothing that yes.
As in the prosecution, because even in the because see statement of child is something different.
Hmm.
So far, what is the prosecution case after investigation?
Hmm.
Prosecution case is not like that I am involved, my lord.
Now,
Because even the
Otherwise, just a minute, otherwise, as per this, CD, it was only the CCL who fired, is it,
Yes, Lordship.
the case? Hmm?
CCL, Lordship, yes, Lordship, it is, Lordship, eyewitnesses, they have seen.
It was only the
Yes, Lordship.
child.
Yes, Lordship. That his background also, they have highlighted, he is very notorious.
There is also eyewitness.
Yes, Lordship.
Can we just see? Not the present accused. The present accused is only arrested only because he has facilitated.
I facilitated my lord, in the sense I went for a duty. I
Hmm.
came back in the home.
Hmm.
In my official vehicle, I kept the gun
Hmm.
without even thinking that this guy, he would take the things and he would do like that. It's a very unfortunate incident, my lord. And since I am an officer, I have fully cooperated. Even if all the I myself took the CCL to the police station.
But
and
from the police station
yes,
and
my lord.
the guns,
That
gun taking
that
out.
part, my lord.
Hmm.
That's why I said, my lord, that. But with good faith, only to the discharge duty that was
Hmm.
taken. My lord.
That is happening.
Yes, sir. That
And probably,
Lordship, here, Lordship, actually, eyewitness, they have not seen one of that exact that incident, Lordship, but they have, Lordship, stated that the once some bullet have been, Lordship, purchased from their shop, Lordship. One
who
shopkeeper-
purchased?
That, Lordship, actually, bullet had been purchased, but, Lordship, it was not been, Lordship, entry was not been made, Lordship.
JJB where? Which
it is
district?
remanded to Pasigat.
Pasigat, JJP.
Pasigat.
Yes, Lordship.
Because my lord, this is not the prosecution case at all. Because
Yeah,
even
that is there.
CCL statement.
No,
is
now,
wrong.
now curiosity,
Right.
because if there is no clear cut, where any statement, any of the witnesses stated that it was JJB, oh, sorry, CCL who fired. Hmm.
No, that is not there, Lordship.
It's
because
not there.
They have only, Lordship, they stated that
Okay, what we'll do,
that the OC was looking for that child, Lordship, on that day, Lordship. That was their, Lordship. But incident, there no one has, Lordship.
Mhm.
No, my lord, then in that, my lord has seen it.
Hmm.
More than 1 month I have been
Mhm.
in jail. Otherwise, my lord, this
So,
is not the case, my lord. So my prayer, my lord, if this honorable court intends to go through some, I may be allowed to interim bail, my lord, at least.
Two-
So that
two-
next day, if
three
my-
more days,
if I-
3 more days. Let me just see, because now curiosity, there is a, see, yeah. Because he's connected with, his statement is necessary actually.
But my lord,
Yeah,
now
I understand,
Now-
but then,
prosecution, because even CCL is the prosecution, what is the prosecution case? What is my role at all?
Hmm.
Is it something I have been just arrested in the air? What is the allegation against me?
see the history, the conduct of the petitioner is as such that you have to actually think about that also.
My lord, of
Hmm.
course, I could not foresee to that level because in August I took him to my house.
Hmm.
I will
Yes,
take
yes,
care
I
of
understand,
everything.
but then let us see
And I
once, just once,
I thought that
because he is the most important witness here, and he probably would be called here also to give witness, and his statement is important. So just let me see once. We'll fix it on Tuesday.
my lord, Tuesday will be true. Today is 18th.
No, I just
But
would like
can
to
it
see,
be on
you have submitted what,
Friday, my lord.
this Friday?
Yes, ma'am.
This Friday would be, is it possible?
I'll try, Lordship.
Hmm?
I'll try, Lordship.
Okay.
They can send through the WhatsApp also nowadays.
Mhm.
1 page.
No, it's JJB because staff is different again. JJB, I don't know whether the staff is available.
Lordship. I'll try, Lordship. If that day not possible, then again we'll fix on Tuesday.
Okay. Okay.
क्या case? क्या नाम है? Good, legally good.
Miss El Hage, Lana additional PP. Submitted, although she has received the case diary of which PS case you said?
Pasigat PS, Lordship.
Hmm. Yomcha PS case number 0220.
Yomcha PS or Lordship, sorry.
Number 2. However, the statement of the statement of the child in conflict with law is not available, which according to her would be available before the JJB Pasigat.
Yes, Lordship.
Okay. In view of the above, let the will it be a record?
Lordship, as per the Lordship, this case study, Lordship, they have interrogated Lordship. They have interrogated this
Okay.
Lordship. So must be there some.
Okay, the relevant record
Yes.
be called for from the JJB Pasigat. The scanned copy of the relevant record of the. Do you have the number?
No Lordship number, so I don't have.
Okay, it's
We'll make
fine
it
only,
copy.
the same number, I think, no? Call for, okay, list is matter again on Friday.
Lordship.
My lord,
Okay.
if on that the prosecution fails to bring, my lord, because this cannot be also routine.
No,
Our
that is why I'm saying to ensure.
My lord knows liberty is kept in the highest pedestal.
Hmm.
It cannot be so casually because
Hmm,
they
so
will
that
not
is why-
drop or so take. Otherwise, our own entire fabric of the entire constitution, my lord,
It is,
it will have no
it is,
meaning at all.
it is she who is helping you. Otherwise, I was fixing on Tuesday only,
My lord, my lord.
but then she says that
That's why, my lord,
she'll
because-
try her best to produce on Friday. It was for you.
Because what happens most of the time on that day also we say that it is not. We are
And-
not saying that they are responsible.
Hmm.
Maybe
If she, knowing that on Friday it is not possible, if she is cooperating, and if I allow your submission, then it will be difficult. Both of you are in together. It will be difficult.
because I am completely innocent in this
Ah.
case. My lord. That
Yes, yes, it appears. But then not that also. So
But-
far as so far as the gun is concerned. Okay, next.
Item number 10.
What is this IFO?
I already my order was passed for calling of record
Calling of?
from the office of the my lord, returning officer and some official. And
Okay, this is okay. Election petition.
election petition.
Okay, just a minute, huh? What was the last order?
Last order was
Are we in the IA or in the main petition?
I am my lord.
In IA.
Yeah.
The last order, as per the last order, record was called for.
Yeah, record. I was directed to
Except for
take
the
steps.
document mentioned at serial number so and so. What is the office note here?
Office note I have seen my lord only record of
Subject must be stated within-
document number 10 was received. Others, the some
Just a minute, sir, just a minute, sir. Okay, only except for 3. Serial number 3.
I think there is serial number 10.
Hmm?
Document number 10.
3 is not required to be called for.
Yes, it is.
He was dropped.
Not withdrawn.
Hmm.
No, as per office note, my lord, I have seen the one record has received by the registry.
Objection to the production of the document. Okay, yes, because regarding 5 and 6, he insisted that it is a necessary document. And this is a supporting document, according to him. So he wanted actually, it was to be dropped along with the serial number 3, but then he insisted. And that the same are necessary for proper adjudication of the connected election petitions. That is why we will settle. Though, let the record be called, okay?
Yes, ma'am.
It was called for this prior. Evidentiary value shall be considered at the stage of evidence, isn't it?
Yes,
After receipt.
after receipt. of
It
the-
may not be required also.
Yes.
Or at that time, you can raise the objection. Yeah, okay, yes, that observation made. Except for document 3. See, in serial number 3. So office note said which document they have received?
No, document number 10, Your Lordship.
Only 10.
Only 10. This
So
from the,
they are different authority, isn't it?
they are the different authority.
So that is why now we have received 10.
Yes. So, my lord, matter may be listed after receiving the record. From the officer concerned.
Okay. Where is the office note?
This office note, this note, there is 17.
In the main.
In the, no, my lord, in the I only.
Receive a letter from the additional secretary law. Civil secretary Janagat show the regarding to the document. This is the document.
Yes,
Notification.
notification dated, my lord, 26.
Is this the document? Have you seen?
Yeah.
Is this the document
My lord.
you are seeking for? Okay. Heard Mr. Nyasam Jongsam, petitioner in person, staff. Also heard Mr. Eskariori, Land Council for the opposite party number 1, staff, para. The office note dated 18/11/2025 reflect that the registry, the registry has received a letter from the Additional Secretary, Law, Legislative and Justice, Civil Secretariat, Itanagar, through the Senior Government Advocate. Flag A. Which document? Where is the document you have mentioned? From the law department, which document, serial number?
Serial number 10.
Okay,
Notification.
notification, okay. Document regarding the through the senior government advocate regarding the document mentioned in serial number 10 of the list of documents filed by the applicant stroke election petitioner. So this way, if we receive all these documents, newspaper, it will be difficult. It has to be compiled with, isn't it?
Yes, my lord. It will compile at the time of my lord hearing.
Okay.
by the-
Then the said document is marked is document A for identification. Okay. Stop. Huh? The rest of the document is still awaited. In view of the above, the registry shall issue reminder. Okay.
Yes.
Serial number 10 of the okay. Or who will have to issue reminder? The petitioner?
Actually, the petitioner has to take a step for.
He has taken steps and
press some
therefore
for issuing.
you take fresh step then. Because since the document is not coming,
My lord, yes.
because it has to be in the election, not the registry, it has to be you who has to take the steps. Okay, the applicant, petitioner, stroke petitioner shall take fresh step, stroke reminder, okay?
My lord.
For the rest of the document within 3 days.
Within 3 days.
Hmm.
From today itself, my lord.
Today. Okay,
From tomorrow.
3 working days. 3 working days, we'll say. 3 working day, okay?
From today, they can do it. Okay, one.
Okay, then we'll say,
From tomorrow.
from tomorrow, so 3 working day would be till Sunday. Sorry, 3 working day would be till Monday, sorry. Okay,
My lord.
within 3 working days. 2 working days is enough for the election petition. It has to be disposed of early. Tomorrow and day after tomorrow. Within 3 days from today. Oh, Saturday also will give, okay? Within 3 days. Huh? That is till Saturday. Okay, stop. Age agreed. upon by the parties. Let this matter be listed on. When?
It will take time, I think, your lordship. Maybe in
No,
month
no.
of December,
No,
second week.
no. November last will list it.
Matlab,
On,
within a
uh,
week. Now today is 19, 18.
Okay, December, 2nd December.
Matlab, let it be on 8th of December.
No, 8th of December. This court
Or
will not
lordship
sit.
will not be available.
So we'll
Then-
fix it on 2nd.
Lord-
2nd December. Okay.
Second December.
Okay. Is it okay?
My lord, it is Panchayat is coming also. I have
No.
to book also. That is the problem.
It is your case.
Yeah.
Then when do you want, you say?
Changla.
When do you want?
8 will be the preferred date. Otherwise,
In the 8th, this court will not sit here.
Then, my lord, as and
Then,
when
then,
for
then,
the-
as per your convenience, my lord.
4, 5, till 5, this court, no, 4, till 4. Thereafter, we do not know when this court will sit again. So we'll see, fix it on 4. Okay, till it,
Convenient.
okay, 4th, okay? Okay.
I'm like,
Relax, my lord.
Item number 11.
My lord, in this case, I am also respondent. But we have also filed an IA for directing the insurance appellant respondent to deposit 50% from the awarded amount. That IA's number is 277/25. I think there is not mentioned.
This is IA for what?
That IA is filed by the
No,
respondent.
this IA,
Yes, my lord.
item 11,
Item-
filed by the insurance company.
Yes, ma'am.
Who is for the insurance?
I'm for the appellant.
Okay,
Yes.
limitation. You have objection?
I have no objection subject to the deposit of 50% of the awarded amount. of
No,
their
this
shares.
is, see, condonation petition only, this
Yes.
IA.
Yes, my lord.
In the condonation petition, how would we direct? So, just a minute, huh? What is another IA? This is condonation. And then the other one is,
IA number 277/25. That is for filed by the respondent.
this IA 277 is by
For by respondent applicant.
the respondent file, whether they have deposited,
Not my lord.
then why you have filed this?
My lord, this is for IA for directing the appellant to deposit the 50% of the awarded amount from their shares. Because of my lord, that in the trial court judgment.
This is for release only, not yet deposited.
Yes.
Why this? Have you seen your application? An application for release, not yet deposited. Why you have filed this?
My lord, that is therefore I am filing to direct the appellant to deposit the 50% of the
First, you
awarded.
file for deposit,
Yes.
then you file for release.
Yes.
Have you seen your petition?
Yes, my lord,
See.
I have just, there has to be one word is missing to directing the, an application for directing to release the 50%. That has to be mentioned. That is also missing, my lord. But in my peers.
An application for releasing 50% of the awarded amount, not yet deposited.
Yes, my lord. But in my pair section, I have mentioned it.
Huh?
But in my pair section, I have mentioned it.
Why it is different in the post title and prayer? The is different. One is for deposit, one is for prayer is for release. So deposit, and the application is for release. Why?
My lord, there is.
How would we understand the code?
There is mixing of two words, my lord. In my prayer session, I have.
If you okay, Mr.
Anduza.
Yeah, for petitioner, applicant.
Yeah.
You're for respondent.
Yes, my lord.
Which side is for the petitioner?
Yeah, I'm for the petitioner.
Stand in your own place.
Okay.
Don't confuse the court, huh? Okay.
Okay.
Heard, Mr.
And Ruza.
Learned counsel for the applicant. So also heard Mr. Das. Learned counsel appearing on behalf of the respondent number. Sole respondent. Sole respondent. Stop, huh? Para. This is an application filed under section 5 of the Indian Limitation Act 1963 for condonation of delay of 274 days in preferring the connected appeal. Stop, huh? Connected appeal, huh? Against the judgment and award dated 8/8/2024, passed by the learned member Motor Accident Claims Tribunal, Bomdila, in MSC case number 17/2023. Stop, huh? Para. Where have you stated the ground for the delay? The ground for delay in preferring the connected appeal has been explained in para. Which paragraph? Three, one, para 3 of the petition. Stop. Application. Stop. Upon hearing and on perusal of the ground stated in the above paragraph, this court is of the view that the applicant was prevented by a sufficient cause for not preferring the connected appeal within a stipulated time. Stop. Moreover, the respondent has no objection condoning the delay in preferring the connected appeal. Stop. Para. In view of the above, the delay of 274 days is hereby condoned. Stop. With the above, this IS stands allowed and disposed of. Okay. And in the mail, man already registered, it appears. You deposit 50%.
Yes, Lordship. Within one month, maybe grant for
Okay.
deposit of the said amount.
Hard, Mr. Same. Learned counsel for the appellant. Okay. Para. This is an application filed under. No. This is appeal only. Okay. This is an appeal filed under section 173 of the MB Act 1988 against the judgment and award dated 8/8/2024, passed by the learned member Motor Accident Claims Tribunal, West Cameng District, Bomdila, in MSC case number 12/2023. Your challenge is on what? Quantum. Mr. Das, what is his challenge? Okay, it's fine, okay. The appeal is, but then they have not filed any IA for stay of the operation of the,
Yes.
hmm? There is no prayer for stay, then how do we? Okay, interim, okay. The appeal is admitted on the, subject to the condition that when the appeal is admitted, stop, the appellant has also pray for pray for stay of the operation of the impugned judgment and award dated 8/8/2024. Stop. Since the appeal has already been admitted, comma, the operation of the impugned judgment and award dated 8/8/2024 passed by the member motor action claim tribunal Bomdila in MSC case number 12/2023 shall remain stayed subject to the condition that the appellant deposit 50% of the total awarded amount before the registry of this court within 6 weeks from today.
Yes. Yes, sir.
Then they'll have to pay their own share only. Okay, then 50%, 50% of the, where is the judgment? Where is the operative portion of the judgment page? Award. So total 11 lakhs. Okay, what is the half of the 5,75,000? We'll mention the amount only. Okay, subject to the deposit of 2,87,500 before this court, before the registry of this court within 6 weeks from today. Stop. Para. On 6 less from today, stop. On such deposition being made, comma, the respondent claimant shall be allowed to withdraw the same on proper identification, on proper verification and identification by the by her advocate. Okay. Registry only.
Yes.
With the above. Just a minute. Okay. Then you're not going to file objection. Then in that case, after the appeal is admitted, and call for the record, call for the relevant record. Okay. Issue notice. Since Mr. Bidas appear and accepted notice on behalf of the sole respondent, no formal notice need be issued to the said respondent. Okay, then that prayer for stay would be, okay, that will come. Okay, least is matter after 4 weeks, because record we have called for. Then in IA to IA, another IA for 277. Okay, then in view of the order passed today in main case, okay, make appeal 17 AP 2025, comma, this IA stands disposed of. Okay. Yes.
Item number 13.
1-3, Lordship.
Lordship, 13 to 15 is the same case arising out of same accident.
Same.
Yes.
Here also same, similar order. Similar.
Yes, similar order, but yes, but our ground of appeal is there is no liability regarding this third party occupant which is covered under the comprehensive policy, not in the act policy, Your Lordship.
Who is the victim here?
My wife.
Whose wife? Who is respondent? Who is this husband? Owner or what? Driver, owner?
Co-occupant.
And who was the petitioner there? Sorry, the claimant there? In that case? No, no, yeah, in which 14? Awarded. Okay, awarded. So, they are also half percent? 50%, okay. It will be, which one is IA? Here, this is also condonation. There is no condonation petition. Here, IA is only for the release.
Yes.
Whether they, any order for deposition, they are not praying for stay. They have to pay, they have to file an application. Then while appeal already admitted here, all for the record. Now they let them file application for stay. Then there will no stay. You go for execution.
Yes.
They are not. Okay, just a minute. Then you deposit then. You have not filed separate application. Actually, separate application, stay application should be filed.
Yes, Lord.
One IA. But then here you have made a prayer. You in the main make appeal only, pending disposal, and probably from the next time will not accept it. Such prayer, you have to file separate application for stay petition. Okay, Mr.
And
Planning Council for the appellant. Also, Mr. Vidas for Vidas, you are appearing for the first time. Have you filed Wakalat Nama? Well, no, your name nowhere reflected. Yes, there is on 048. Yes, Biardas. Okay. Also had Biardas. Para. Whether record was called for record, have we received the record? No. The trial court record is still awaited. Stop. At this. Okay. Still awaited, huh? Stop. Mr. his name appellant, huh? Learning counsel for the appellant insists for the stay of the operation of the judgment and award dated 16/10/2024. Pass 16/10/2024. I mean, it's the operation of the impugned judgment and award dated 16/10/2024. Stop. Para. Since the appeal has already been admitted, comma, the operation, although the appellant has not filed separate IA for IA praying for stay of the operation, comma, this court feel that since as there is a interim prayer in the main appeal, comma, this court is of the opinion of the view that the interim prayer can be considered in the instant case. Stop. Accordingly, yes, just we can. And since the appeal has already been admitted, comma, the operation of the impugned judgment and award dated 16/10/2024 passed by the learned member Motor Accident Claims Tribunal, Tribunal, Bomdila. So it's a long one, Bomdila, in MSC case number 13/2022 shall remain state subject to the condition that the appellant deposit how much here? What is the total awarded 10 lakhs? Okay. And then here directed to the two insurance company here also. Deposit the 50% of the total awarded amount before the registry of this court. Within 6 weeks from today. Stop. List this matter. After that was 4 weeks or 4 weeks. Okay. And in IA 229. Heard Mr. B.R. Das, Learned Counsel for the applicant. Also heard Mr. M. Tangja.
N. Ruza.
N.
Ruza, Lordship.
N.
Ruza.
Learned Counsel for the respondent insurance company. Staff. Para. Not yet deposited. Learned Counsel not yet deposited. This prayer is then in the main appeal only will cover, on such deposition para being made, comma, the respondent claimant. How many claimants? Okay, claimant shall be allowed to withdraw the same on proper verification and identification being identified by our advocate. Okay, then here IA, in view of the order passed today in MAC appeal number 07/2025, comma, this IA stands disposed of. Okay. Why, Mr. Beardas, your contact it appears something, don't do like that. Before deposition, you are asking for release. What is this? You are running after money only. Care about the procedure also. What are you doing? Don't do like that. Okay. Yes. Next.
Item number 14.
This was not 14.
That's 13, that one also.
This was 13. Okay, 14 also same. But arising out of the same accident, similar or other.
Same,
Okay.
similar.
Then in the main appeal, record has come there also. Then why you have? I've said that the record is still awaited in the earlier case. This has the record is still awaited. Just okay. Remove that that part. Okay. Then here also, that item. This is 14. Okay, item 14. Here also like 13, same in the make appeal, number will be different. And then the amount also will be the half, okay, 50% of the total awarded amount, okay. And then here also allowed to withdraw, okay, in the main. And then IA also dispose in view of the order passed today in the make appeal, okay, same. Amount here, whether two insurance involved or only one insurance, then it's only 50, then 50%. The amount, no need to mention the amount. Okay, since, okay, then in all the case, since the trial court record has been received, let this matter be listed for hearing after 4 weeks. Okay.
Item number 15.
Arising out of same. Okay. Same.
Same, Lordship.
Then here also similar, or the party name will change, and then the amount withdraw also.
576,620.
Here also releasing, Okay, here also first. Similar order in the make appeal. Parties, no, don't have to write the party, and then advocate's name, stay of the operation, okay, and then IA also dispose of, okay, this is IA 231, IA also dispose of, okay, and here also record received, matter be fixed for hearing after 4 weeks, okay.
Item number 16.
All right.
Yes.
16 in IA.
The
Honorable Court had directed the circle officer to take steps upon the Gaubura. I've checked the record. CO Bandarjua has submitted the report, and in the main CRP, the service, the notice upon respondent is found to be returned unserved. May I pray that the press system.
In the IA is for what?
IA was filed on the subsequent development, because earlier this honorable court had stayed.
Okay, they proceeded thereafter also.
They have issued one more notice that was again challenged by way of this IA. Since the delay customary authority, they have not received the notice, therefore the honorable court had directed the circle officer to serve the notice. Check the record, it is found to be served upon the.
Civil letter, so from the.
However, against sole respondent, the notice is found to be unserved, returned unserved. spread it,
Which one? In the main? Okay, in the main, you just write. Mr. Arko, Land Council for the petitioner. Hmm. Where, return answer.
Papa, the envelope is there. The record. It has been returned.
How many respondents were there? Are there?
So
Sole respondent. What is this? This registry has received the letter. Twenty-six. 29. Where is flying air? Okay. Who is the respondent?
Marjung, it's Marjung Rido line.
So the step was taken upon the address not found. Okay. But it is not in the office note. Hmm?
Yes, I have checked. It is not in the office record, but then the
Let them record in the office note. Okay. Had Mr. Koyu, Land Council for the petitioner. The letter from the circle officer, capital and same is best. This circle officer was directed to report before this court.
yes, in the IA. However, it seems like there's some miscommunication or confusion by the registry because in the IA, because in the main case, the notice was not received by the Gaupura. Therefore, in the IA, I prayed that the notice may be served through circle officer Banderdua. So he can.
In the main case, also circle officer has written letter to the head GB or presiding customary judge. Okay. So okay, then in this case. Okay, it appears that the notice upon appears that the notice upon the respondent, the sole respondent, has returned unserved with the postal remark addressing not just insufficient address. And the address not found, stroke insufficient address. In view of the above, Mr. Koyu, Land Council for the petitioner prays for allowing him to ascertain the correct address and to take fresh steps. The prayer is allowed. Stop. Fresh steps. Sorry, steps upon the respondent within 2 weeks from today by a registered post with by a registered post with AD as well as by usual process within 2 weeks from today. Stop. List this matter after 4 weeks. Because it's the address not found, insufficient address. You ascertain the correct address, okay?
Item number 17.
No, please, Lordship.
Yes.
Lordship, it's a joint criminal petition for quashing of FIR and charge sheet, Lordship. Except here, the accused involved is a minor, CCWL, child with conflict in law. So accordingly, the respondent number 5, who is the father of the minor, is representing the minor, and the settlement was arrived between all the petitioners on 2 occasions, Lordship. Lordship, your first set of FIR was lost on 30/3/2025 by
Just a minute, this is quashing petition.
Yes, Lordship. Since the accused involved here in his
It's-
minor.
It's a joint petition.
Yes, joint petition, Lordship.
The petitioner number 1 is the victim,
Is the, yes,
informant,
informant number 1.
informant, and
Yeah.
2 is,
2, 3, 4, 5 is also an informant.
okay,
They have lost separate FIR, Lordship, about the incident.
okay,
But their FIR has not been registered since the contents of the FIR are identical. Therefore, the subsequent FIR filed by petitioner number 2, 3, 4 was tagged along with the FIR of the petitioner number 1, Lordship.
there is 2 petition or 1 petition? Only 1 petition.
Only one.
Earlier also filed,
Earlier, yes, it was earlier criminal petition number 90 was filed, Lordship, for quashing of the FIR filed by the petitioner number 1. At the time of it was settlement was arrived just after 15 days of registration of FIR filed by the petitioner number 1 was. But even after filing of charge sheet, the accused petitioner didn't aware about the subsequent FIR loss.
okay,
Accordingly, on 8/9/2025, when that criminal petition withdrawn was listed for consideration before this honorable court, then only the learned additional PP has informed about the subsequent FIR and filing of supplementary charge sheet.
against the accused.
Yes,
Yeah.
against the accused.
Ah.
Then accordingly, Lordship, it was withdrawn, and subsequently the settlement was arrived between all the other subsequent informant, that is petitioner number 2, 3, and 4. Then this fresh criminal petition was filed.
Okay, so this is record.
Yes. Record.
Case charge sheeted?
Yes, charge sheet, Lordship. Even in fact, Lordship,
Then
on
if it is a juvenile, then it's before? Which court?
Principal Magistrate JJB UPL also.
It's before the principal magistrate.
Yes, Lordship.
So this record is of the principal magistrate.
Yes, Lordship. It was
JJB.
in earlier criminal petition number 90,
Hmm.
record was already called, Lordship.
Okay.
So accordingly, it was withdrawn on.
So this criminal this record
Yes.
of the JJB covers for
Yes.
all the informant.
Yes, Lordship.
Altogether, how many informant? 5.
Informant 4, Lordship.
4 informant.
Yes, Lordship.
They have separately lodged FIR or
Yes, separate FIR, Lordship. But no separate registration. It was clubbed together.
okay,
because-
clubbed together with the initial one.
Yes, initial first FIR, Lordship.
Okay. So now what is the stage before the
It is
JJB?
now, yes, Lordship. On 6th, Lordship, someone was issued by the principal magistrate. Trial had just commenced, and someone had been issued to the CCWL for appearance on 22 January 2026, Lordship. So I have accordingly enclosed the summon along with in this criminal petition, Lordship.
Okay.
Lordship, all the after registration of FIR, in fact, the first settlement was arrived between the complainant petitioner number 1, since she has considered the integration of the juvenile into the society and his prospective career also. Now the juvenile accused juvenile.
What the juvenile is, what he used to do?
He is studying in class 11, Lordship.
Class
at-
11 student.
Yes, Lordship. At Kasinga School, Dehradun, Uttarakhand, with hostel facilities, Lordship, at present.
You have to help me on the numbers, the case number which is to be set aside.
Lordship. Lordship, there is
I'll take,
single case, Lordship.
huh?
Only single
Single
case.
case.
Yes. First,
Okay, what I'll do is today, time is off. What I'll do is, order reserve.
yes.
Supposing if for any case, if reference or some confusion regarding the case number and etc., I'll get it listed. Okay, otherwise it will be done.
Yes, Lordship.
Okay.
Yes.
Heard Mr. K. Lolen, Land Council for the petitioner. Who is this petitioner?
Petitioner is all.
He
Petitioner,
is authorized person. Who is the petitioner?
petitioner number 1 is the complaint.
No, and the juvenile is represented by
Yes, his father.
his father.
Petitioner number 5.
Okay, just then, huh?
Yes, Lordship.
Mr. K. Lolen, Land Council for the petitioners. Also had Mr. Tai. Sorry, PP for the state respondent, staff para. This application under section 528 of the BNSS, Bharatiya Bharatiya Nagrik Suraksha Sanhita 2023 has jointly been filed by the petitioner representing the child in conflict with law. Here is petitioner number 5 and the petitioner number 1 to 4, comma, all informants
Yes.
in
Itanagar.
Ita WPS case number 11, 2025 under section 77 stroke 79 of BNS read with section 66E stroke 67 stroke 67 capital within bracket capital A of IT Act 2000. Okay, the party, I think so far as the party is concerned, that's correct.
Yes, correct.
Okay, then I'll dictate. Then dispose of.
Lordship.
Okay.
Lordship.
But other you may not get today.
No, no, it's
The other reserve
Yes,
CAB
yes.
is also there.
Yes.
So other
Yes,
may take
Lordship.
1 day at least.
Lordship.
Just a minute. This is item 17. 17. Okay. So. Yes. Any other? Just a minute. Just 1 minute. Yeah. 18. Horizon out of same.
It's also.
The insurance are present, still present. You're tired.
Lordship.
Hmm?
No, Lordship. I'm a bit confused with.
Oh, not tired. It was only confusion.
Yes, Lord. Yes, Lordship.
Okay, then 18 is also arising out of same accident.
Same incident, not incident.
Different incident. Okay, we'll get it listed on Friday. Okay, sorry, Thursday. No, Thursday. Okay. No time. It's almost 5. Okay. Due to positive time, the matter could not be taken up. Let this matter be listed. Monday. We'll say Monday. Okay.
Okay.
Is only item number 90 is only to financial Congress court to withdraw the deposit amount. And children only deposit.
Okay. 18 on Monday, okay. Okay, where is 19? Had Mr. B.R. Das, Thane counsel for the 19, 9 counsel for the applicant, so. By an order, by which order it was directed to deposit? Already deposited? Okay, by which order? By an order dated? By an order dated 10/9/2025. This court directed this court directed the respondent insurance company to deposit 10% of the total awarded amount before the registry of this court. Stop. In compliance of the said order, the insurance company, the respondent stroke insurance company has deposited, how much amount deposited? 5,10,000 before the registry of this court. Stop. By filing this application, IA, the applicant, claimant, prays for release of the 50% of the total awarded amount, release of the said deposited amount. Stop. Para. Who is the for insurance company here? Oriental. You are for Oriental. Okay.
Yes, sir.
So since you have deposited, no objection.
No objection.
Okay. The Miss.
Sir, I'm appearing on behalf of my senior.
Okay, you are Miss.
Sangeet
Appearing on behalf of Mr.
Udeka.
Udeka, Lana counsel for the respondent insurance company has no objection. Stop. In view of the above, this IA is allowed. Stop. The registry shall release the deposited amount to the applicant claimant on proper verification and identified by their counsel. Okay. To release the amount deposited by the respondent insurance company to the applicant claimant. Okay. On proper verification. Okay. With the above this IA stamps disposed of. Okay. Then the main, it is along with the main only. In the main, their presence be recorded and at least after 4 weeks. Okay. And 20, due to paucity of time, the matter could not be taken up. Let the 20, 21, 22. Okay. Let this matter be listed next week. Okay. Monday. Okay. 2021 on Monday.
2022, here, my lord. My name is not reflected in the cause.
Okay. In 22.
In the Michitara is supposed to be there.
Okay. Then, okay, 2021 on Monday. Okay. And in 26. Okay, on 26. Okay. 26. Okay. Then in 22, Mr. Who is for the applicant here? 22?
Mr. M. Tara.
No.
NUV is written there. It is supposed to be M. Tara. I'm conducting the conducting council here.
Nunu UB is not the council.
No. Okay. He's my associate.
Okay. In IA 22. Mr. M. Tara, Land Council for the applicant. No one appears on behalf of the respondent. Staff as prayed for by. Is it okay to be listed it on 26?
26.
Or when do you want?
Tomorrow, day after. Tomorrow it will not be possible.
Okay, had Mr. M. Tara, Land Council for the applicant. So who submits that instead of his name, the name of Nanu UB has wrongly been reflected in the course list. Staff. For this, okay. So the registry shall, the registry is directed to reflect the name of Mr. M. Tara, Michi Tara, as land counsel for the applicant in the cause list. Okay? Please pray for, when do you want, you said?
Tomorrow,
No, not possible tomorrow. Day after tomorrow or Monday?
day after tomorrow is
Or-
Friday.
Huh?
Monday or
Monday, okay. As prayed for by the land council for the
Yes.
applicant, let this matter be listed on Monday. Okay. It's done.
you finish, Lordship.
Okay. Monday by reflecting the name, his name in the cause list, huh?